Respecting Judge in his remarks earlier noted that there is that draft JICS bill currently under development. We've provided our comments on that JICS bill to JICS themselves in response to their call for input. One of our comments in terms of that bill is that we don't believe that the bill in its current form sufficiently deals with the membership of JICS as part of South Africa's national preventive mechanism. In the Subcommittee for the Prevention of Torture, in interpreting OPCAT requirements, has a very strong recommendation for states like South Africa that in order to ensure independence of these oversight mechanisms, there should be clear legislative independence. So that's the mandate of the institution, establishing its powers, election process, terms of funding, lines of accountability to all be in a legislative instrument. And in the absence of JICS legislation at this stage, we believe that the powers, functions and mandates of JICS within the current Correctional Services Act should actually be amended to include specific reference to its role within the South African National Preventive Mechanism. And we recommend that the bill be amended to also provide recognition of a specific budgetary allocation to allow JICS to undertake its work according to that NPM mandate. And that NPM mandate really entails its leadership in terms of the coordination and governance of the National Preventive Mechanism, as well as the operational elements, which is the preventive monitoring visits and the transfer of data and its expertise around recommendations through to the NPM. Our final recommendation on the bill relates to the Chief Executive Officer. So we say that the criteria for the appointment of the CEO should be strengthened along the lines of other independent oversight mechanisms. And we've had particular reference to the Public Protector and the Auditor General in our written submission. The reason we've argued this is that it's twofold. The first is a practical matter, that it should be a fair and transparent process of recruitment that involves Parliament and is free from interference with the department over whom JICS is exercising its oversight mandate. This will ensure public confidence in the institution. But secondly, it also again relates back to the guidance we're receiving from things like the Glenister case, from OPCAT and the Subcommittee for the Prevention of Torture, which have pointed to security of tenure and clear leadership appointment and removal processes as being a necessary functional aspect of what independence means in this context. In our written submission, we've actually provided wording that we would recommend be included in a revision of the Act that speaks to the need for the establishment of a committee of the National Assembly to initiate the appointment, clear criteria in terms of who would be a fit and proper person to hold the CEO position, and then a process in terms of also public participation in the scrutiny of applications for the CEO, and formal steps in terms of the removal of the CEO. That concludes my presentation. We have made a written submission available to the committee, and I'm happy to take any questions. Thank you very much, Honourable Chairperson.
Thank you very much for the presentation. Are there any questions? And there are no questions. Your presentation was clear, and members have understood it, and they have no questions. Thank you very much. You can stay to listen to the other presentation and the responses of the department thereafter. Can we now invite the South African Catholic Bishops' Conference?
Hi, good morning. Good morning, Honourable Minister. Honourable Chairperson, and honourable members of the committee, as well as esteemed colleagues. Sorry.
You have
Could I-
15 minutes.
15 minutes. Okay, I'll go through this as quickly as possible. And perhaps I should just say that this submission isn't as technical or as expert as previous submissions. The Catholic Church regards prisoners as a very vulnerable sector of the population. So we would like to set out how we think prisoners should be treated. So we welcome this opportunity to comment on the Correctional Services Bill, and we welcome the Constitutional Court's confirmation of the decision of the Western Cape High Court regarding the independence of the Judicial Inspectorate for the Correctional Services and the rights of prisoners. The question is whether or not this bill successfully addresses these issues. We will comment briefly on some individual clauses in the bill, but the main intention of this submission is to set out the general attitude of the Church to questions of incarceration and the rights of prisoners, and to highlight some concerns. The Church believes that the state has a twofold responsibility to discourage behavior that is harmful to human rights and the fundamental laws of civil life, and to repair through the penal system the disorder created by criminal activity. However, more than preserving and defending public order, the Church argues that there is a moral element involved in the correction of the guilty party, which moves beyond punishment towards redemption and reconciliation. The Church's social doctrine is clear that there is a twofold purpose here. On the one hand, encouraging the reinsertion of the condemned person into society, and on the other, fostering a justice that reconciles, a justice capable of restoring harmony in social relationships disrupted by the criminal act committed. Furthermore, because of her belief in the inalienability, dignity that we all bear, the Church argues that prison environments must uphold and respect human dignity. The balance between appropriate punishment and effective rehabilitation must be maintained, and so we must continue to engage with our penal system and hold it to account. Prisons are very violent places, and South African prisons are no different. While the Correctional Services Act and case law are clear that it is the duty of the state to ensure safe custody and to maintain standards of human dignity, the threat of violence forms an integral part of the prison experience. Measures to mitigate this violence, as this bill sets out to do, are to be welcomed, but they are limited. An article in the Daily Maverick in 2020 pointed out that our justice system over-reliance of locking people up has led to overcrowding and inhumane conditions. In some places, forced personnel to cram 3 times more prisoners into cells than intended. Some don't have beds. Living conditions are unhygienic and unsanitary. Violence and ill treatment are common during arrest and while in prison. Sexual abuse is a common phenomenon, and it is linked to overcrowding rates and understaffing. The COVID-19 pandemic has aggravated these conditions. The recommendation of the Judicial Inspectorate of Correctional Services, JICS, are not automatically binding. This contrasts with jurisdiction in other countries where some prisons inspectors' findings are binding. For example, the Zambian Human Rights Commission, the Correctional Investigator in Canada, and the Prison and Probation Ombudsman in the United Kingdom. JICS's statutory limitations underscore the urgent need to strengthen its independence and authority. We note that the operational requirements of JICS are set out in the JICS bill, which to date has not been released for public comment. We further note that the introduction of the JICS bill into Parliament is dependent on the approval of the Minister of Finance through Treasury for the establishment of JICS as a national government component with its own funding model. The need to strengthen JICS is urgent, as emphasized by an empirical study which examined incarcerated offenders' perceptions of correctional officers in selected correctional centers. Correctional officers require the voluntary compliance and cooperation of incarcerated offenders to realize the goals of the custodial institutions, but the perennial incidence of violence abuse and brutality, and other forms of misconduct by correctional services officers towards incarcerated offenders are inimical to the actualization of these goals. Using an example of 315 male participants from a cross-section survey, the study assessed whether experiences of abuse and brutality, social distance, and corruption predict incarcerated offenders' perception of correctional officers in South African institutions. This finding further collaborates additional research findings in institutional corrections and in the criminal justice system. The study points to the effects of abuse and brutality and corruption in eroding confidence in correctional officers, decreasing the ratings of their procedural fairness and their overall effectiveness and performance. Furthermore, we note that South Africa is party to the optional protocol on the Convention Against Torture, which has condemned the rape of detained prisoners with or without the knowledge of state officials as a form of torture, as it amounts to intentional suffering for the purposes of punishment, intimidation, or coercion, securing a confession or for any reason based on discrimination of any kind when inflicted by or at the instigation and or the consent or acquiescence of a public official. As such, South Africa is obligated to address this issue, given that violence is rampant inside correctional services centres. It seems clear that there is insufficient recourse for inmates when they are hurt or raped inside correctional services centres. In an incident at the maximum security prison in Leeuwkop in Johannesburg, a number of prisoners were badly beaten. In one instance before the festive season, or warders concealing their identities with balaclavas allegedly entered cells and instructed inmates to lie down. They were literally put in leg irons before assaulting them, demanding to know whether they had drugs in their possessions. Relatives of these victims of assault laid charges against the warders with the South African Police Service, whose members visited the prison to take down these statements. Furthermore, an officer of SAP said that several cases of grievous bodily harm and torture have been reported in the past, but the cases went nowhere as officials from the Department of Correctional Services apparently protected their members, sometimes with the cooperation of medical staff. Family members were able to photograph these injuries in visiting the prison. Family members play an important oversight role and need to be able to report abuse and evidence thereof without fear of retaliation against the prisoner. In this regard, Section 90 should be amended to recognize the right of family members of inmates to make complaints to JICS and to have their complaints independently addressed. JICS has previously submitted that the prison authorities are in violation of the Constitution when they resort to solitary confinement as punishment, as this could be interpreted as a form of torture. Furthermore, JICS has expressed deep concern about the harsh impact of solitary confinement, which can result in severe long-term health problems, including depression and suicidal tendencies. There is no evidence that solitary confinement deters crime. Moreover, research has found that approximately 25% of people in prison and 35% of those in jail who had spent 30 days or longer in solitary confinement during the previous year had symptoms of severe psychological distress. The rates were similar to those who had spent only 1 day in violation. The bill goes some way to addressing our concerns, as Clause 2 requires that an inmate subjected to solitary confinement must be notified of their right to appeal to JICS. Clause 3 provides similarly in cases for the use of mechanical constraints. We support both these clauses. In conclusion, because of our belief in the inalienable dignity of every person, a value shared and upheld by the South African Constitution, the Church argues that prison environments must uphold and respect human dignity. The balance between appropriate punishment and effective rehabilitation must be maintained, and in so doing, we must continue to engage with our penal system and hold it to account for these ends. We must help ensure our prison system is a place of punishment, yes, but also one that respects human dignity and gives prisoners and the entire community a real chance at rehabilitation. We would urge that the Minister of Finance would release the funds necessary for the independence of JICS as a standalone entity. This would go some way towards the transformation of our punitive and harsh criminal justice system. I thank you.
Thank you very much, Ms. Law from the South African Catholic Bishops' Conference. Are there any questions, members? I have Honorable Nivo Trochen, followed by Honorable Maseko Jele, in that order.
Thank you, Ms. Law, for your presentation. Thank you for the presentation from the South African Catholic and Bishops' Conference. Just one question. What support or relationship do you have with JICS as well as the Victim Empowerment Program that the department has? Because the Victim Empowerment Program always has a need for assistance when they have discussions with the victim and the victim's family and the perpetrator. So I'm just curious whether the South African Catholic and Bishops' Conference does have any role to play with regards to the Victim Empowerment Program. Thank you.
Thank you very much, Honorable Nivo Trochen. Honorable Maseko Jele.
Thank you very much, Chair, and also thank you, Ms. Lu. I think Honorable Nivo Trochen has covered me, Chair, because I also wanted to ask a question in line with the issue of the victim empowerment programs, or any thought that as to, because we always have problems that with the community, the society is always complaining that it seems as if we are putting more emphasis on the issue of the rights of the inmates against the rights of the victims. So I also wanted to have you in line with that. I think Honorable Nivo Trochen has covered me. I just wanted to add on top of that. Thank you, Chair.
Thank you very much, Honorable.
Thank you very much.
Ms. Law.
Thank you very much for both those questions. Unfortunately, the SACBC does not have a relationship with JICS. The kind of we're not a specialist organization. I deal particularly with those persons who are vulnerable, women and children, gender issues, and families. But we do advocacy on part of the Catholic Bishops' Conference. We're not actually involved with many of the measures that go towards the remediation of injustices. We do have prison chaplains who are an important part of the ministry of the church. And we do have relationships with other organizations who are involved with the rights of prisoners. But unfortunately, we do not, our organization does not engage with the victim empowerment programs. And the other, likewise, unfortunately, we don't take up those issues. This is always a bit of a complication with the nature of our office, is that we raise issues, but they don't seem to be able to follow them through. But the point is, we are making submissions to you on behalf of the church, raising our concerns in the hope that these concerns will be addressed. It's an awkward space to find oneself, but unfortunately, we can't take up all the issues on which we try to comment. But thank you for those questions, and your questions are noted, and I will raise them. So thank you.
Thank you very much. Honorable Maseko Jele, is that an old hand or a new hand?
I think, Chair, thank you very much. It was a new hand, but I think her last statement has covered me because I wanted to find out if maybe is there any way that they can also accommodate that in their endeavor in assisting also the inmates in terms of balancing these rights. So I think the last statement has just covered me. Thank you, Chair.
Thank you, Honorable Devote Trohan. Is that an old hand or a new hand?
It's a new hand, Chair. Thank you, Chairperson. Just a follow-up question, because she indicated that there are prison chaplains. I just wanted to know if Ms. Law do you ever get any report back from the prison chaplains about their role in the victim empowerment program? Just wanted to know if these chaplains and the ministry in the prison, whether they assist in terms of the victim empowerment. So just, do you get any report back on? IB Anthem again, please.
The Bishops' Conference as a whole would get report backs on those issues.
Okay, thanks.
Thank you very much. Thank you very much, Ms. Lowe from the South African Catholic Bishops' Conference for the input. You are the last organization to make a presentation. What will happen now, we are going to move to the next item, which will be adoption of the reports. It will take not more than 10 minutes. And then we will come back to this process where we will be getting responses from the Department of Correctional Services. We are just giving the presenter and the department a breather so that they can go and drink some water and tea. So we'll just be proceeding with the reports. Committee Secretary, can you flag the report? The first report. A report of the Portfolio Committee on Justice and Correctional Services on the draft notice and schedule determining the rate with effect from the 1st of April 2022, at which salaries, allowances, and benefits are payable to Constitutional Court judges and other judges annually for approval by Parliament in terms of Section 2, Subsection 4 of the Judges' Remuneration and Conditions of Employment Act 2001, Act number 47 of 2001, dated 30 August 2023. Are there any corrections on page 1? The report is taken as read. It was circulated. Are there any corrections on page 1? On page 2, is there a mover for the adoption of the report?
I move, Chair.
Honorable Ngola moves. Any seconder? Honorable Nico Trochen.
Honorable Neodruchen seconds, Chair.
Thank you very much. Any objection? No objection. The report is agreed to. Report of the Portfolio Committee on Justice and Correctional Services on the draft notice determining the salaries and allowances of the Public Protector, Deputy Public Protector, and Commissioners of the South African Human Rights Commission with effect from the 1st of April 2022, dated 30 August 2023. Are there any corrections on page 1? Page 2? Page 3? Can we correct consideration?
Honorable Wilmer adopts the report.
Honorable Nuvot Drugan moves for the adoption of the report. Any seconder?
Seconded, Chair.
Honorable Mola seconds. Any objection?
No objection, but please note that the DA reserves its position.
The Democratic Alliance reserves its position. The report is agreed to. Report of the Portfolio Committee on Justice and Correctional Services on the draft notice and schedule determining the rate with effect from the 1st of April at which salaries, allowances, and benefits are payable to magistrates annually for approval by Parliament in terms of Section 12, subsection 1 of the Magistrates Act 93, Act number 90 of 1993, dated 30th August 2023. Are there any corrections on page 1? The report is taken as read. No corrections. Is there a mover for the adoption of the report? Is there a mover for the adoption of the report?
Honorable Drugan moves.
Honorable Nuvot Drugan moves. Any seconder?
I second.
Honorable
Okay.
Masood seconds. Any objections? No objection. The report is agreed to. Thank you very much. I think that brings us to the end of the reports. Am I correct, Committee Secretary?
Yes, Chair.
Thank you very much. We will now proceed to the response by the Department of Correctional Services to the submissions on the Correctional Services Amendment Bill. Members, would you want to wait for 11:15 or would you want to take a short comfort break now?
Chair, if we can maybe return at 11, that would assist somewhat.
Okay. Let's come back at 11 o'clock. That's a 10 minutes break.
Colleagues from TCS, can you sort out the issue of sharing during this break?
Yes, put it in
You've changed your name to South Africa now. Hey, one day. Okay, Mr. South Africa. Can you try and share?
Oh, I see.
Have you won a beauty contest? Can you try and share leadership quickly so we can quickly find it? Yeah, and the colleagues who are going to present, can they test their audio? Just to make sure.
We are together in one office.
Yeah, are they audible, leadership? Because whenever you are,
Yeah, we're using one instrument.
it's a bit low too. I don't know if it's only from my. Oh, it's fine. It's fine.
Is it fine?
Yes, no, it's fine. I think my volume was a bit down.
Oh, okay.
Yeah. Can you test leadership? So we can also have a break. Yeah.
Visible? Is it moving?
It's moving, but I don't know. Maybe it's your percentage at the bottom. It's 154.
Oh, yes.
Bottom right. Go to 100 or something because we can't see the entire document. Yeah. Just increase it maybe to 110. I don't know. Yeah, but now I can see the entire document. Yeah, you'll play with it. Okay. No, yeah, sure. We were good. Yeah, you can remove it now until we start at 10. Thanks, Mr. South Africa.
It is now 11 o'clock. Can we proceed? We will now invite the department led by the Deputy Minister to respond to issues arising out of the public hearings. DM, would you want to make any remarks before you hand over to the department? Deputy Minister?
Chair,
Honorable Chair?
I think the Deputy Minister is remember he sent the apology earlier. He said he'll just introduce.
Yes. Well, thank you very much. Thank you for that. Thank you for that. National Commissioner? Who is the person with an iPhone?
Thank you, Honorable Chairperson. Good morning to honorable members. Apologies, Chairperson. The person with the iPhone is myself. I've been failing to name myself on the platform. I'm Mahoti Samuel Tubakale, the National Commissioner of the Department of Correctional Services. Honorable Chairperson, the Deputy Minister did converse with me during the break to indicate that he will take leave from the platform as indicated at the beginning of the meeting. So I confirm that the Deputy Minister is not on the platform. Honorable Chairperson, with your permission, I request that we proceed to respond to the submissions that were made. Mr. Van Wyk will then present our responses. In principle, Honorable Chairperson, we agree with the submissions that were made, specifically the submission that was made by JICS. Mr. Van Wyk will deal with the details. There are issues that were raised in the submissions that are issues that we are treating in the JICS bill. And as I have indicated, Honorable Chairperson, Mr. Van Wyk will then deal with the details. Through you, Honorable Chairperson and honorable members.
Thank you very much, National Commissioner. You said it's Mr. Van Wyk. Mr. Van Wyk.
Yes, Honorable Chairperson.
Okay. Now, thanks. Mr. Van Wyk, can you proceed?
Good morning, Honorable Chair, and good morning, honorable members of this committee. Also, esteemed guests and colleagues. I am Job Van Wyk. Before we start, maybe as an introduction, we want to express our sincere gratitude for all the submissions received from the Correctional Services people. We welcome and appreciate all public comments received pertaining to the bill, but also in the main regarding the Principal Act.
Mr. Van, can you come closer to the mic? We can hardly hear you.
Can you hear me now, Honorable Chair?
Can hear you now. You can proceed.
Thank you, sir. Yes, as I was saying, we welcome all public comments concerning specifically the Correctional Service Amendment Bill. The Principal Act being the Correctional Services Act of 1998, and any and all proposals regarding the enhancement of the performance of the department's mandate. All submissions have been duly considered, and we rate it as of critical importance to the department and discharging its mandate. It is, however, noted that most of the content of the submissions relate to the Principal Act and not necessarily to the specifics of the Correctional Services Bill, and more specifically the objects of the bill. These submissions, however, will be fully considered during the greater review of the Principal Act, and also is included in the JICS bill and the debate surrounding the JICS bill for further processing. In the main, the CSA bill seeks to procure the impugned sections, Section 88A, 1B, and Section 91 of the Principal Act. After many deliberations and consultations regarding the bill, especially with JICS, the further issues or further sections were inserted or amended through the bill to strengthen the independence of JICS at this stage with regards to those critical areas for now, and also to enhance cooperation between the DCS and JICS. We may also just was received or was made or handed down that a JICS bill would be utilized to cure any defects that the court might find, but also it was the intention of all parties concerned that a JICS bill be developed and put through its paces to repeal all relevant sections concerning JICS in the Correctional Services Act, mostly situated in chapters 9 and 10 of the Correctional Services Act. And then basically that the only provisions regarding JICS that would be that will remain in the Correctional Services Act and through different amendments would be then the obligations on correctional services and its members and management towards JICS. So that was the ideal or the idea from the onset. The only reason why there's the Correctional Services Amendment Bill that is before us today, the only reason for that is because of time. The deadline of the Constitutional Court was at first the 4th of December 2022. However, there were some delays with regards to determinations from Treasury, and also delays with regards to establishment of JICS as a government component through the two departments involved, the PSA and Treasury. And a decision was made to firstly apply for extension, which was granted by the Constitutional Court to the 3rd of December 2023, and then to take the CSA bill through its paces to cure the impugned section. So from the onset, we just want to highlight that is the intent or the purpose of the Correctional Services Bill. And it's also the intent in adding to that, and as was agreed, the parallel process with regards to the JICS bill. However, the JICS bill could not be tabled together with the CSA bill or even published for public comment because of the outstanding issues that we had with regards to issues from Treasury regarding the funding model and the transfer of funds and the budgetary issues. And on the other hand, also the issue concerning compliance with the Public Finance Management Act, where it says that this, well, in principle, it means that if the CEO is the accounting officer of JICS, it can only be so if he's part of a government component or a national department. So that is how the CEO can become the accounting officer of JICS. And DPSA, as was already alluded to by the Honorable Inspecting Judge, Justice Cameron, earlier, that DPSA is already engaged and busy with that process. Be that as it may, just also quickly, with regards to the JICS bill, we are feverishly busy with attending to the JICS bill. The last version is version 20. We have applied for a SEAS exemption certificate. We are looking into the possibilities of further engagements or submissions to the NCCS, although there's already been submissions made, and the bill was already provided to the NCCS some time ago. There's also further engagement with the Office of the Chief State Advisor regarding the content of the bill. So we are busy with those preliminary processes. As soon as those processes are concluded, it will be taken through to the various committees, DEFCON, JCBS, Task Duties, and Cabinet Committee. But before it can reach Cabinet, it is done through a Cabinet memo, as we are aware. And in that Cabinet memo, we have to, amongst others, also indicate the financial implications for the state. And because of that unknown situation, currently or quite recently, that would also not be taken through. And also, obviously, of the fact that JICS is not yet created or established as a government component, although it's an advanced stage. So that is just basically the background to just give clarity as to why there are two bills and what the status currently is of the JICS bill. If you then allow me, Honourable Chair, if we were then to go to the physical responses to the submissions received, and I hope we didn't leave out anything. I also agree with the previous speaker, or one of the previous speakers, that none of the issues are more or less important than the others, but we found it prudent to respond to these. And should there obviously be further questions, we are more than welcome to attempt to answer them sufficiently. So on your screens, as we have shared, is just a brief high-level summary of our responses, the department's responses to the various submissions. We'll just touch on it briefly. The first submissions that we are responding to is on the submissions received from APCOF, where it mentions or talks about, it touches on section 91.1 concerning the issue of the departmental vote, that it should be deleted in the Act. We fully take note of that. However, this is a determination that was made by Treasury, and the department does not have control over it. But parties can all be rest assured that the funds are ring-fenced for the sole purpose of JICS. DCS has no control over those funds. And we want to reiterate what our National Commissioner has said, that the department's stance has always been and still is that we fully support for JICS to be independent, being it functionally independent, operationally independent, legislatively independent, or financially independent. We are definitely in the same boat with regards to that. It is just all the processes that need to be completed to achieve that at the end of the day. But yes, as I say, the DCS has got no control over the funds, and also it does not have control over the determination made by Treasury, as it does not fall within the mandate of the department. Further to that, in the end, the CEO, as the accounting officer of the establishment of the government component, will then have full control over the funds allocated to JICS. And being it through the departmental vote is just used as a conduit, or so to speak, for lack of a better word, for the funds then to be channeled through to JICS. The department will have no say, no control, no effect on the budgetary issues of JICS, or even as the utilization of funds, etc. So it's our humble submission, Honourable Chair, that section 91.1 remains unchanged. Then turning to the comments regarding the National Preventive Mechanism, we fully agree with those comments, and those are addressed in the JICS bill. So that will be addressed in the JICS bill, and so there's no necessity to address that in the Correctional Services Act, as at the end of the day, the JICS bill will repeal and replace basically those provisions in the Correctional Services Act concerning and of relevance to JICS. Further comment was made, or further statement was made by APCOF concerning JICS's budget, that it must be included in a specific allocation to support its network. That will be deliberated and debated with Treasury as they hold the proverbial purse, and it's for them to basically make a determination of that issue. Then turning to Section 88A of the Correctional Services Act, and especially the appointment criteria of the CEO, APCOF have made a submission that the appointment revisions should be strengthened in line with other independent oversight mechanisms, and to also include Parliament in the process, and that it's free from interference from PCS. If one pauses there, the bill at paragraph 4C it has been amended, or is amending subsection 2 of Section 88A, in that previously the CEO was appointed by the National Commissioner, and that is amended to the Minister. And if I just go briefly into the wording of the following paragraph, the appointment, career incidents, and other conditions of service, including salary and allowance of the CEO, are regulated by the Public Service Act. Now, that has also been the situation, that is also the position in the current Act. So the only wording that was inserted was the wording of career incidents. Turning to that insertion of career incidents, we also made a proposal that there should be a definition for career incidents. We have definitely considered that, and whilst considering the bill and deliberating on the bill and consulting the bill, also with the Office of the Chief Advisor, this issue was also discussed. But if one has regard to the context within which it's used and where it originates from the Public Service Act, wherein it's also not defined, because it refers in context to all career incidents of the CEO being appointment, or for example, i.e., appointment measures, secondment, transfers, termination, demotion, etc. So we humbly submit that we are of the view that there should be no need to define career incidents in this regard. And then with regards to the appointment measures and requirements, as we have said, it's already covered by the Public Service Act. It's in line with it should be in line with the Public Service Act, but that does not end there. Our recommendation is that although all those will be addressed in the JICS bill eventually, and it will not form part of the Correctional Services Act, those provisions in the JICS bill is aligned to the Public Service Act, and the regulations that will follow from the JICS bill, from the JICS Act, at the end of the day, will, after consultations with DPSA, include the more detail with regards to the appointment requirements, processes, and those things. So that is our submission with regards to the comments on Section 88A. Then turning to the South African Catholic Bishops' Conference, again, thank you very much for the submissions. We take note that the intention of the submission is not on a technical level or a specific level to look into the nitty-gritty of the correctional services amendment bill. But the main intention is basically just to talk about the question of incarceration and the rights of prisoners. We take note of that. Thank you. There are, however, some specifics mentioned that has relation to those sections that we propose to be amended. Those refer to the main Section 30, 31, and 5B, wherein the conference have mentioned mentioned or proposed that there should be measures to mitigate violence in prisons and that it's limited in the bill. With regards to those, and we'll also respond later on to 95B, but whilst we are at that point, with regards to Section 95B, firstly, those events or those incidents that are referred to there, which creates mandatory obligations and requirements on the department to JICs, is a consolidation of what's already in the Correctional Services Act. So they're already elsewhere in the Act where it states that JICs must be informed and it must be reported to them, and there's a couple of additions there. So it's not a closed list at this stage, or it's not a closed list at all. But it must be specific with regards to the reporting framework, so that there is no ambiguity or vagueness with regards to those provisions. When we deal with the general review of the Correctional Services Act, it also forms part of the discussion document, wherein further public comments will be invited on the possible extension of that list. So will also be addressed, as I say, in the general review of the Correctional Services Act. With regards to the general comments on the Correctional Services Act, not necessarily on the bill, on the issue that recommendations by JICs are not binding, we have heard all the submissions, and we've read all the submissions and taken it to heart. But as the Expenditure has said, there is common ground that will be reflected in the JICs bill concerning the reasons that the department must provide should it not implement any recommendations or some recommendations of JICs. So, but we propose that it is dealt with during the typing of the JICs bill and also the general review of the Correctional Services Act. With regards to its reference, the conference's references to Section 90 of the CSA, they are of the view that the section should be amended to recognize the right of family members to make complaints to the JICs and to have their complaints independently addressed. As correctly indicated and observed by the inspecting judge in his letter of the 25th of August, and that is already, it already falls within the scope and ambit of this, the JICs, and they already are dealing with that. So all family members of inmates do have that right, and it's already exercised. But in the main, the conference is in support of the amendments to sections 30 and 31 contained in the bill. And with regards to section 91 of the bill, it commented that prisons should release funds necessary for the independence of JICs. We have already now dealt with that process. As the CEO, Mr. Messer, has indicated earlier, that there's been extensive engagements with Treasury regarding the budgetary issues and allocation of funds. So that issue is dealt with. Then, when we move on to the Detention Justice Forum, the DJF, we take serious note that the bill does fall short of the overall function and operational establishment of JICs as a separate independent body as contemplated in Tsonke. We are, however, of the view that the bill, as we mentioned earlier, seeks to address in the main the two impugn sections, Section 88A1B and Section 91, as found unconstitutional by the Constitutional Court, and because of the fact that there's a deadline to cure those sections. With regards to the extent of the judgment and the rest of the judgment, all that is going to be implemented and going to be dealt with in the JICs bill. And also,
Our Senator, you were cutting.
Am I audible now?
Yes, you are.
Thank you, Honorable Chair. If I might proceed, your leave. So those issues, the rest of the issues that were addressed in the judgment, will be and is addressed in the JIXPO and also in the general review of that. We understand that without the JIXPO or having being able to give comments on the JIXPO, together with the CSA would color the picture, so to speak. But we've already mentioned why there's separate bills and why the JIXPO could not be traveled with the CSA. With regards to sections 30 and 31, we're not going to go into detail with regards to that. Also, on those issues, those are issues that we've taken out of all the comments possible to the bill, but those will be dealt with further in the general review of the Correctional Services Act. It must be mentioned that these amendments were proposed by JIX, and the department really accepted to insert those into the bill. And so this is what was done, and further consideration will be given definitely with regards to the general review of the Correctional Services Act when it involves segregation and category strats. Turning to Section 88, capital A of the bill, the forum has commented that there should be clear provisions on the appointment criteria and dismissal process of the CEO. We have already mentioned, we have already responded to that concerning APCO's submissions, and our submission or our response remains the same. So that will be addressed whilst doing the JIXPO and in consultation with the PSA regarding the final details regarding such measures of the CEO. With regards to Section 91, they reiterate what APCO have submitted regarding the issue of the quadrennial vote. We have already responded to that, but the same submission should suffice with regards to this point. The same with NPM and also the references to OPCAT, that all will be dealt with, at least dealt with in the JIXPO, and further deliberations and consultations on that matter and issue, and also in the general review of the Correctional Services Act for that matter. Because one of the reasons for the general review of the Act is to align it to ratified international instruments where our legislation backs, and also to address certain other issues, prominent issues that have come to the fore in the past couple of years. Turning to Section 95B, we've also replied and responded to that in principle already. And this will be addressed at the end of the day in the general review of the Correctional Services Act. Then turning to the use of binary pronouns or gender binary pronouns, we take note of that, and that is also built into the general review of the Correctional Services Act. But for purposes of the bill, there's only one space or one paragraph where it is mentioned, where there's reference to his or her. That is at paragraph 4E, where it says, any matters relating to misconduct and incapacity of the CEO, based on the inspecting judge, who shall refer his or her decision to the Minister for Implementation. It was suggested, as far as we interpret from the submission, that those references should rather be other than they or theirs. So in this instance, we submit that for obvious reasons and the best of reasons that the reference to he or her is correct in the circumstances. But we do appreciate those, and we'll definitely deal with those linguistic issues in the review of the Correctional Services Act. we've already commented on the absence of the JICS bill whilst they've been discussing the CSA bill. And then also, the forum also raised in its submission, written submission, that the CSA does not provide for whistleblower protection clauses, the assurance and confirmed about it, which was also part of the discussion document on the review of the Correctional Services Act. Honorable Chair, that is our submission and the responses to the salient issues raised by the commentators and the organizations. We thank them for those submissions, and we are in your hands and the hands of those on the platform. For any questions, thank you so much. Please submit. Thank you.
Thank you very much, Mr. Van Wyk, for the presentation. Members, are there any questions? No questions. Thank you very much, Mr. Van Wyk. I think you can proceed to now prepare us for the clause by clause dealing of the bill. So in our next meeting, we will proceed to clause by clause. Is that in order, members? Would I take it that...
Yes, Chair.
Thank you very much. That silence means consent. Thank you very much, Honorable Horn, for clarifying that. Can we now proceed to the next item? Thank you very much, National Commissioner, Mr. Van Wyk, and to the rest of the team for the job well done. We will meet, I think, next week when we will be dealing with a clause by clause. Thank you very much. And thanks to the organizations that made presentations to us today during the public hearings. I think you can say that most of the issues will be catered for in the JICS bill, but most of the suggestions that we have made have been taken on board by the department, especially when they will be dealing with the JICS bill. They have made an undertaking that they will be taking some of those suggestions on board, and to the extent that they apply to this bill before us, some of them have been taken on board, and that is the spirit of our participatory democracy, that we need to take into consideration issues raised by members of the public. Thank you very much for making the presentation and to enhance the bill before us. Thank you very much. Members, can we now proceed to the last item, deliberations of the Judicial Matters Amendment Bill? Mr. Misa?
Thank you for the opportunity, Honourable Chair. May we humbly request your permission to exit the platform?
No, you can. Thank you very much.
Thank you so much. Take care. Bye-bye.
Bye-bye.
Huh?
Good morning, Chair and honorable members. I'm sorry, Chair, you were muted.
Sorry. No, I was saying, how are you, Mr. Sibilimecha?
I'm okay now, Chair.
Thank you very much.
Thank you. I'm not sure if the Deputy Minister has already logged in. He had indicated that there is a function he's attending, but he will then join in, yes.
Yes.
Yeah, I still have some challenge. Sorry.
You still have some challenges?
Yeah, with the network. So I requested Mr. Bonani to assist if it's possible, because I'm using a cell phone, so our network indicates that it's very poor. So I wouldn't be able to work through the laptop. If that is possible, I'm not sure if they could assist me. Yes, I do see, yes, the presentation. If I may proceed, Chair, the summary, having looked at the public hearings and the submissions that we received, we have then prepared the responses. So some of them, we have highlighted the areas, or I'll highlight as we go on, the areas where we will be agreeing to, also suggesting that there could be some amendments that we can make to the bill. Just to start with, I will try to be more faster so that we can go through the document within time. Is that in clause 1, we received comments from the Women's Legal Center and the Law Society, which the Women's Center was in support, but then the Law Society had indicated that they've got some issues with regard to the addition of the subsection 4 to the section 51 of the Magistrates Court Act, in that it allows the magistrates to step into the adversarial fray, in that the authority being empowered to call in challenges. And therefore, even if we consider this, we then are agreeing that we should remove or delete subsection 4, which is then be left with subsection 5. Then we'll have to change the numbering, that the current subclause or subsection 5 will then be subsection 4. Then the similar comment on the next page was made by the JJS Prince Law SC. Then on clause 2, the JJ Prince Law SC is just welcoming the proposed amendment. And then going to clause 3, the Law Society of South Africa has made some comments severally there. But the first, with regards to the use of the word current or transactional and saying vice versa, is basically the same type of an account. So we're agreeing to that and saying we'll then have to remove the current account and will remain with the transactional account. Then the further comment with regard to that, I think it's just some of the explanations around why are we using, why are we empowering the chief master to make directives and the like, but instead of the minister. So we basically are saying the minister should not be involved in that regard in a way. Then if I may go to paragraph F, which there is a comment that he has got some little bit of a response that we detailed about, is that the commentator made an oral submission that the amount of 1,000 rand be increased to 5,000 rands. So our honorary consideration were of the view that we should rather avoid mentioning the amount, agreeing to increase it, but therefore empower the chief master to determine an amount to be paid through a directive, so that we avoid the process that should there be a need to increase the amount, we then have to go back to Parliament to request an increase of the amount. Then if we then may move to clause 4, the clause 4, then there is just an issue of the use of the word may versus must or shall, and we have the view that the word may allows or permits the master to exercise the discretion when making an assessment of a matter. Right? Therefore, we rather believe that the usage of may is correct, as must remove that power to exercise discretionary powers. Then clause 5, the Law Society of South Africa made a comment with regard to the word may as well. We are of the same view that there should be an exercise of discretion in certain instances where there is no compliance with the law, and then the master must be afforded the right to sort of deal with the non-compliance where such appears to be the case. Then clause 8, Chair, just below the page, it's a comment from the Law Society of South Africa as well. They're proposing that the Chief Master's authority be made subject to the direction of the Minister, and we are of the view that we should not engage the Minister in administrative processes. Rather, the Chief Master is the one responsible for the overall management of the services that are rendered under the Administration of Estates Act. Therefore, should remain as the person that will give directives. If we may move then to clause 9, Chair, the Law Society of South Africa again is making a comment with regard to the regulations that are to be made under the Administration of Estates Act, that they should be made by the Minister in consultation with the recognized bodies. Therefore, saying the provision on its own for now was made to correct a technical and drafting oversight that was in section 103, as it was amended in 2017 by inserting the subparagraphs EA and EB. However, with regard to the proposal of in consultation, we have the view that the making of regulations is done through consultation where the other bodies or the public will make comments, and making regulations in consultation with specific industry representatives will require all parties to agree to the regulations, which is going to be a difficult thing to make, and therefore present challenges with regards to the finalization of the regulations. Therefore, regulations should be as empowered, or the power given to the minister should be following the process of consultation that the minister will then have to review and consider and review the specific regulations with regard to the comments that are made. Therefore, we are not in support of amending the clause. Clause 10, which talks to there is a comment from the Women's Legal Center, and they are supporting the amendment, however, with the reservation in that the clause 2B sets out the nature of the offense will be excluded from the provision. Therefore, we're saying we will note in the comment, and that clause 10 proposes the insertion of the new sections 57B, 7C, 7D into the Penal Procedure Act, and it says the criteria for the determining of the offenses that will qualify to be declared as offenses for which an accused may pay a fine without appearing in court. And the criteria is already, it points out which type of offenses that may be included as part of those. And then the criteria that is, which already points that an offense must, for instance, not be the one that involves the infliction of mental, psychological, or physical harm on another person, which would include domestic violence related, because they are suggesting that we must be specific with regard to domestic violence related offenses. However, the criteria already includes that. Then another comment from JJS Prince-Law SC is basically welcoming the addition, as it creates the mechanism to remove currently uncertain whether all admission of guilt findings are recorded as previous convictions. However, there's an issue that is raised with regard to the criteria that is contained in the new section 57B2C that needs clarification in terms of what is the high volume offenses. I think we have then reconsidered and thought the whole of paragraph 57(2)C should rather be deleted, as it creates a bit of, even in terms of the understanding, it's not very clear that people will easily understand, but we can do without it, because the entire criteria does cover the type of offenses that are important to be covered. Then the Africa Criminal Justice Reform, in the same vein, where commenting that they are of the view that although they comment the bill in dealing with the issues regarding decriminalization of minor offences and expungements, it falls short of providing substance of offence that are subjected, although we are saying is guidance that is provided in terms of how or what is the criteria for the expungements of these offences. And further, they are talking to the grounds and criteria that must be considered to determine whether an offence may be decriminalised and expunged. I thought we have clearly articulated the criteria. And the determination of the offences will be made in consultation with the National Director of Public Prosecutions and after consultation with the Minister of Police. The Minister may, if necessary, publish the list for public comments, although in terms of the current provision is not a requirement. Therefore, as it comes to clause 11, Chair, just need to mention that when we're engaging around the provision of section 1.6, this did not necessarily come out in the comments, but there was some engagement that the principals had with the regional court president. They pointed out the issue that the bill amends section 186, which refers to a proviso where when there's information required by the court in relation to infrastructure related or operational matters that creates delays in respect of the proceedings or the trials proceeding, it's rather should be section 342A, which necessarily talks to unreasonable delays in trials, because the person to be called in as a court manager or even the DDG for court administration or ultimately the DG is not necessarily a witness in the proceedings. Therefore, we're proposing that the proviso should rather be moved to section 342A1 of the Criminal Procedure Act. Then in clause 12, Chair, there's a comment from the Law Society of South Africa, wherein it is pointed out that the draft amendment references bear incomplete section number. Clause 12 proposes the repeal of section 12.21.2A of the Matrimonial Property Act, and instead that we should rather refer to 2A2 that is being rendered unconstitutional. But then we had studied the judgment again, and we are of the view that the Council Court ruled that section 21.2A to be unconstitutional. It did not pinpoint specifically to subparagraph 2 as it is being suggested, and therefore it is on that basis that we have kept the wording that it should be 21.2A that is being deleted, and the Council Court dealt with section 21.2A in its totality. Hence, we are not pinpointing specifically to subparagraph 2. Clauses 11, 19, 20, 24, 25, 26, and 27, Chair, are comments from the Women's Legal Center, which are simply supporting the amendments. Then the same goes for clause 28, that is being welcomed. Clause 35, which talks to the repeal of laws. There's a comment from Media Monitoring, wherein they are welcoming the clauses 35, 1 and 2, and with regard to the criminal defamation that is to be abolished. And they are basically saying, however, they're raising a concern that from the transitional arrangement, it appears that the criminal proceedings that are already pending, they should, and not concluded, they should proceed, and they are of the view that such should not be the case. And we are therefore, in respect, agreeing that we can remove clause 36. On the next page, Chair, is still with regard to the repeal of laws with the Women's Legal Center, is the same comment that we have made, that the clause 36 could be removed. The clause 30, Chair, is one of those that didn't come out as well, but then the Rules Board, the Secretary's Rules Board, had pointed out that the current clause 30, the way it reads, it has been amended, but then in trying to introduce the online, the electronic service, it might have resulted in a conflict with the current already amended provision, and therefore we are of the view that we may remove the clause 30 in light of the cohesion, and therefore the issues that will be dealt with could be things that could be dealt with in respect of the rules that the board may make. I think that, Chair, concludes the responses that we've made. Therefore, just in conclusion, there are several proposed amendments that we're agreeing with flowing from the issues that have been pointed out, and therefore we should be able to assist the committee in preparing and highlighting specifically those when, if the committee agrees, we will be led by yourself, Chair, and the honorable members. If I can conclude in that regard. Thank you.
Thank you very much. What was your last comment?
I was just saying, with regard to the proposals that we are also making, that we can remove or delete certain of the subsections and other wordings or wording. We will be guided by the chair in respect of whether such are acceptable. Thank you.
Thank you very much. Let's welcome the Deputy Minister, John Jeffrey. Welcome, Deputy Minister. Your hand is up. You can proceed.
Thanks, Chair. No, I just wanted to say I'm at a community meeting, so I'm going to be speaking later, but I've connected up and I'll be here as long as I can, but then we'll have to go and make a speech. But I think Mr. Sebelemecha has presented well, and it then would be in the hands of the committee for further questions, comments, those kinds of things, and guidance if there's agreement with what we are proposing to change or whether there are further amendments. Thanks, Chair.
Thank you very much, Deputy Minister. Members, any comment? Honorable Stephen Swart, welcome back from the Chief Whips Forum.
Thank you, Chair, and thank you to the department for their comments. I need to catch up a little bit, and obviously I'll need some time just to consider these issues. Chair, I'm not sure how you are processing, because I think the committee spoke about deliberations as well, which might be a bit of a challenge. But whilst I appreciate most of the amendments are technical, I would need to look into the issue of the magistrate's discretion and the suggestion under clause 4 and 5, the may and the must. I think we would probably need more justification there. But that it makes a big difference, obviously, whether it is discretion or peremptory. I particularly welcome, as I've said before, the issues relating to the criminal records and expungement. You know, that is an issue we have raised continually during COVID-19, and the committee has supported that, so that is to be welcomed. I'm not too sure on that one aspect of the generality that was referred to by the one commentator, that resulted in a deletion of the one clause there. That's under the decriminalization aspect. I'm just trying to find where it is. But the issue that I wanted to just really get into a little bit was the deletion of the transitional clause 36 under criminal defamation. And it seems that the department, now one's got to take a step back and understand that this bill would have been presented through cabinet with transitional arrangements, accepted as such, and now the department is agreeing that that clause 36 should be deleted. I would like the department to give us any idea of how many matters will this impact. Do we have any idea of pending matters that are before the courts now? And I'm not taking a view either to support it or against it, but one would like to know what the impact would be on pending matters. And obviously one's got to see this against the background of the hate speech provisions as well, which has been dealt with now the hate speech bill in the NCOP. And we all have a background of that bill as well. So, Chair, those are a few questions from my side at this stage, and I just wanted the guidance from you as to how you see this bill being processed, understanding the urgency and that most of the contents of this bill are of a technical matter. Thank you, Chair.
Thank you very much. As much as we said that today will be deliberations, I think it was good that we went through the responses by the department. I think from here onwards, we will allow, after this engagement, we will allow the department now to come with a draft bill, taking everything that we would have agreed to on board, and then we'll start with a clause-by-clause drafting of the bill. But I think first, let's allow the department to respond to the issues you have raised, Honorable Swart. Honorable Deputy Minister.
Thanks, Chair. No, I just thought, because I can get called away at any time, let me maybe start. But I think that, yeah, the committee got this response yesterday. They do need to consider it. There's also the issue of, are there any further amendments from members of the committee, which I would have thought members should be already aware about if they want to do further amendments. I'll leave it up to Mr. Sebelemecha to talk about the may and the must, although my own view is it reads better as may. If you say peremptory, then there's no discretion, and there may be a reason for the master not wanting to accept an affidavit. But just on the criminal defamation, I think there was quite a good submission from during the public hearings on clause 36. The clause that was introduced, I mean, the issue is once a person has pleaded, a case can't be withdrawn. They've got to be found guilty or not guilty. It's something we looked at when we did the bill that was published for public comment on decriminalization of sex work, where we actually said the opposite. But I think the problem is going to be if we repeal criminal defamation, and then suddenly, but people are still prosecuted under it. My understanding is that this matter, there haven't been prosecutions for a very long time, but more recently, I think there's one or two, which are more, I think, politically based. I mean, one of the reasons some in the NPA were supporting the repeal of the common law was that it's weaponizing the National Prosecuting Authority. But the issue would, I presume anyone, so to answer Mr. Swart, I think there's one or two matters where people have been charged. Whether they should be charged is something else. But I think it would be then for them to ensure that for the defense to ensure that their client doesn't plead, and so that the matter can be withdrawn once this the bill comes into effect. But to put in 36 as it is also a bit of an anomaly, because you're basically saying Parliament says this isn't a crime anymore, but you can still be prosecuted, you can still be found guilty if you've already pleaded. So I don't know if that answers it. But that's the anomaly, and we thought it was better just to remove 36, and then it is up to the individual cases to work out what would be happening. I remember during the early 90s when there were amnesties coming out for possession of firearms, and I was practicing at that time that one would always ensure that, or ask the court and the prosecution, which agreed to defer the matter I mean, not to set the matter down for trial before the legal position was finalized, and that worked. I would have thought the same thing could happen. But in direct answer to Mr. Swart's question, there haven't been for a while, but I think there's now one or two. Yeah, so it's not very many at all. Thanks, Chair.
Thank you very much, dear. Mr. Sibele Mecha.
Thank you, Chair, and honorable members. Currently, section or clause 4 that talks to section 34, if we look at the amendment, the word may is not being amended or inserted. It's already in the act. But as we indicated, the issue is here we are dealing with the issue in respect of which the payments are to be done and an affidavit by the executor where it is declared that a creditor was paid. And then they are going to be issuing an affidavit to indicate that that amount has been indicated through an affidavit. It might occur that it is not acceptable that it is done in an affidavit format without further perhaps a proof. And therefore, if you say it's a must, then it leaves the master at the mercy of an affidavit without additional perhaps proof because it says it must be accepted by the master in lieu of such receipt or acquaintance. So therefore, people can simply make affidavit and say, I've issued or I've effected a payment. And we believe that if it's peremptory and there is no discretion, then we might experience challenges. That's our understanding of the actual practicality of this provision. Thank you.
Thank you very much. Are you covered, Honorable Swart?
Yes, thank you, Chair. And the one I couldn't find related to the, on page 6, Judges Prinsloo, referring to the high volume offences as proposed, section 57, capital B2C1, and the department is of the view that clause 57.2C can be deleted. So it seems there's an agreement from the department side with the commentary there. So I'll leave it at that. I just wanted, I've not found that, but I'm clarified on that. I will need to come back on some issues should I need to on further going through the documents. Thank you, Chair. Possibly.
Thank you very much, Honorable Swart. Members, any further questions or comments? None. Can the department proceed to draft the bill, having taken into consideration all the comments made, and then we will proceed to a stage of clause by clause, which will be deliberations. Any objections to that?
No, Chair.
None, Chair.
Thank you very much. That would bring us to the end of the meeting. Maybe before, because we have to allow department time, I propose that we don't meet tomorrow and Friday, and we would meet next week. Committee Secretary, what is the program for next week? How does it look like? So that members of the public can see it.
We're just trying to get to it, Chair. Just a sec. We're going to proceed with deliberations, Chair, with the bills that we want to finalize.
So which means Tuesday could be cannabis and judicial matters with this bill. Wednesday, okay.
Maybe after this meeting, Chair, we can the secretariat can quickly engage with your office just to bring the order.
No,
Okay.
no, this one is fine. So what we
Okay,
will need to work on is the reworked program, maybe for a week after next week, to deal with the issue of Judge Mutata to be on the program.
Okay, Chair. We'll wait for your undertaking on it. Thanks, Chair.
That's good. So for the purposes of this bill, we are proceeding on Tuesday next week. Will that be enough time, DM and Mr. Sibelemecha?
Chair, my understanding, I can speak, I think, for Mr. On Mr. Sibelemecha's behalf, because we did discuss it before, but I think that is fine. I just wanted to raise that, and maybe if we can start with judicial matters on Tuesday, because as you've seen, it's not many amendments. The other thing, though, was just that the Regulation of Interception of Communications Act Amendment Bill, to comply with the Constitutional Court order that was tabled, introduced yesterday, and to please appeal to yourself, the committee section, and to Parliament to ensure that the bill is published for public comment.
And then where is the NPA? Because we have not
The
received
NPA, the Joint Rule 159 was submitted yesterday as well. It's in yesterday's ATC. There's just some touching up being done by the state law advisors. The deadline is Monday. We expect the bill to be introduced this week.
So we will take all those things into consideration in reworking the program, because we would need to get a briefing on the two bills so that we can advertise them. So we need, as part of the reworked program, to factor in the two bills and to factor in the issue of Judge Mutata. Members, is there any objections to that?
No, Chair.
No objection. Agreed to. The meeting is adjourned. So we adjourned earlier than anticipated. Can you take this time to relax and to be with your family members? Thank you very much. The meeting is adjourned.
Thank you, Chair.
Thank you, Chair. Thank you, Chair.
Thank you very much, Mr.
Thank you,
Sibele.
Chair.
Recording stopped.